All right, hello everyone. We are going to begin. I'm going to start off with our opening remarks. On behalf of the Housing Bureau for Seniors, I'd like to welcome you to our annual Senior Living Week. I'm Courtney Beckwith, and I'm the Community Outreach and Education Coordinator. HBS is a community-anchored program of community health services at Michigan Medicine. Our purpose for this week-long event is to bring together the people who provide senior services, resources, and products with those who need them. In response to COVID-19, each of us has had to adapt our day-to-day so we can stay safe and remain healthy. Since March, when the work-at-home orders began, the HBS team hasn't missed a day serving older adults in our community. We are working remotely and busier than ever. For these reasons, Senior Living Week 2020 events are virtual with the exception of our Grab-and-Go Expo. Our solution to bring all the great information from local vendors to you. We are grateful to those vendors and the many sponsors who make Senior Living Week possible. They are listed on your screen. We'd like to extend a special thanks to our event sponsor, Brookhaven Manor Senior Living. Today's presentation is sponsored by Legacy Law Center, and now I'd like to welcome our speaker, Mr. Terry Bertram, whose presentation is titled Legal First Aid Kit for Families and Caregivers. I will go ahead and stop sharing my screen. All right, and you should be able to share yours.
Well, good morning, everyone. My name, as Courtney said, is Terry Bertram, and I'm happy to be with you this morning to talk a little bit about the tools that we need to be able to take care of ourselves, our families, and have our caregivers assist us in that. It's a little different. I prefer that I've done in past years of be in person with you, but we want to make the best of what we have in these circumstances there. Hopefully all of you have gotten over your debate hangover from last night and are able to get a cup of coffee and relax here. So I'm going to talk for a little while, and there will be a chance at the end for a Q&A session here where you'll be able to ask questions, and hopefully we can help you with that. But before I really get started, I do want to do a shout out to the Housing Bureau for Seniors. I mean, we've had the opportunity to work with them in a variety of circumstances over a long time, and they're always helpful. And if they don't have the answer, they'll help us find the answer for different scenarios that come up there. And looking at the sponsors of here, I think that our office has worked with every single one, and that's the value of living in a rich community that we do, in that we do have a lot of supportive services available in our community depending on what your needs are. For us, we're local attorneys. We're located on the corner of State and Eisenhower in what is now called the TCF Bank Building. And for those who are wondering, you know, we're on the third floor, and there's the bank on the first floor, and that bank used to be the Ann Arbor Commerce Bank. Then it was called the Michigan Commerce Bank. Then it was called the Talmer Bank. Then it became Chemical Bank. And now, as of August, it's now the TCF Bank Building there. Now, we've remained there throughout that and will continue to there, but you know, as we all know, the banking industry has gone through a lot of different changes and mergers and acquisitions and what have you. You know, stay tuned. Who knows what the name of our building will be coming up in the future there. But we're conveniently located in Ann Arbor. There's plenty of parking there, which makes it nice for us there. A little about myself. I've been practicing law now. For some reason, I don't think I look any older, but they say it's been 35 years as of next month that I've been practicing law. In addition, I've got a master's degree in counseling, which is probably what I use as much as anything, coupling that with the law and helping families and caregivers as they go down the path of needing services that we'll talk about later there. And have been involved with the community. I currently serve on the board of directors of EHM Senior Solutions Foundation, and formerly served as a director at Gilbert Residence, and serve as the attorney for Pittsfield Seniors. And for those of you who don't know, it's the largest nonprofit private travel organization in the county. And it's a good deal. If you're looking for fellowship as well as travel opportunities, you should contact Pittsfield seniors. I think you will be happy with that there. In addition to that, we're members of national organizations such as the National Association of Elder Law Attorneys and Elder Council, which make sure that we get continuing education and stay up with things. More important than my credentials, if you will, is sort of the family perspective that I come from. I'm one of 7 boys. We grew up in Traverse City. I'm the middle child. I've got 3 older brothers and 3 younger brothers. And my parents sort of informed me in this practice. When we were all still at home, my father had a heart attack and suddenly died. And as a result of that, my mother was now a single parent raising 7 boys on her own. As she got older, some 30 some years later, she had a long-term care crisis where she fell and broke her leg, and that spiraled into other problems, and she ended up going for a 10-year period of gradually first losing her mobility and then other activities of daily living, and going from living on her own to needing support in the home to going into an assisted living environment. In the last 6 months of her life was in a skilled nursing home before she passed away. And that sort of informs me that, you know, in the past, the things that used to kill us, the heart attacks, the cancers, the strokes and that, now modern medicine is keeping us alive longer, but we're more likely to go through a period of incapacity. And so when we think of what tools do we need should that occur, that maybe changes the paradigm a bit, that what we have to talk about. And so consistent with that, our practice, if you look at these pillars here, we cover a lot of different things here. One, the obvious things as far as helping people develop a plan. So this first pillar, estate planning, you know, where we develop wills, trusts, powers of attorneys, healthcare directives, and what have you, for people to have what they need when they need it. Additionally, the second pillar, we help families to administer estates, whether or not they have a trust or it has to go through probate, but making sure that we assist them when that time comes to deal with that. And then next, in the elder law area that you'll hear more about, as families need additional services as they're aging, whether it be financial assistance, VA Medicaid assistance, or having a plan in place so that they have helpers that can assist them, and making sure they're doing things so that in the future, should they need to become eligible for these different programs, they haven't done anything in the meantime to sabotage their ability to become eligible, or on the other hand, have the right tools in place so that others can help them, that they need things there. And then finally, the nature of our practices is, while we're lawyers, we're in the elder area there, we become an advocate and a quarterback often for our clients. And to be able to do that effectively, we have to be engaged in the community, similar to this presentation today, working with the Housing Bureau, but also working with other elder law attorneys, working with home health care folks, hospice workers, hospital discharge planners, funeral directors, financial planners, accountants, a whole bevy of other allied professionals who work with individuals and families. Oftentimes we help coordinate and quarterback, not providing, I mean, they're experts in their own areas there, but to make sure that whatever's necessary we bring to the table to assist families as they go through the changes that inevitably occur. And this bridge sort of shows what we're talking about. Oftentimes, people will talk about, with you, what you need to retire and retire and planning for the good life. And the focus on that is making sure you have the resources to meet your retirement lifestyle goals. And, that's your investments, and your portfolio makeup and that. And that's important that you have folks that can help you with that piece of the pie, if you will. And then at the other hand, often, the traditional estate planning attorney was, okay, you need a will and maybe a couple other documents for what happens and who gets your stuff after you're gone. And it deals with the transfer of your assets when you've passed away, as well as authority and decision making when you can't make decisions yourself. But in the middle of all of this, often not dealt with, as I had one client who said to me earlier on in my career, where I said, okay, here's your documents for what happens upon your death. He said to me, Terry, what happens if I don't die? What are we going to do then? Who's going to be able to help me, and can they do what they need to do? And that's part of what the elder law focus is yes, we will make sure that whoever gets your stuff, but also wanting to make sure you have the helpers in place and they have the tools to provide you the type of assistance you need in the future, should that be needed. And what we want to do is plan for the worst and hope for the best, and making sure we have everything in place. Because one, we know that the cost of long-term care is not inexpensive. If you have to go into a skilled nursing home, you're going to pay in this area anywhere from $8,000 to $12,000 a month. Assisted living, it's going to be, $3,500 and up there. And then if you have someone in the home, that's going to be expensive also. And even if you're relying on family members, they're often giving up, whether it's work. And now, especially with the pandemic, you've got the sandwich generation who can often be taking care of their parents as well as their children all at the same time. And the burden of that can be rather overwhelming there. And if we don't have our things aligned that we need to, we're adding to the frustration and problems for people there as they attempt to help us when we can't help ourselves. And you've got the cost additionally to the employer when the employee can't be engaged because they're now taking care of a loved one who needs their assistance. And it's going on at an extraordinary level in today's arena there. So it's something also to look like if there's ways that we can reduce that burden or make it smoother if it's a burden that needs to be done there. So in talking to people, we're asked, what are your real concerns as you age? And the AARP and some other senior living folks that have done surveys to find out what's important from your standpoint, not what's important to me as a lawyer or your financial planner, but what are your concerns as you age? And the things that you have said that are important to you is making sure you have access to quality health care, that you live independently, and that you have the ability, as much as possible, what we call aging in place or thriving in place, where you have the ability to maintain your independence in the least restrictive environment. Wanting to maintain mobility and control of decision making. And you have the fear of going broke in terms of the cost of long-term care that could be. And hasn't that been exacerbated now of feeling isolated from family and friends there? Those are some of the primary ones. And what we want is to have trusted loved ones who can take over our medical and financial decisions when we need it. Wanting to know that we're doing the best and most efficient way of handling our assets, so hopefully we don't outlive them, and we have the peace of mind of knowing that. And in addition to that, dealing with the healthcare area is we want to make sure when we can't speak for ourselves in terms of healthcare decision making, we get the level and the type of care we want, and we don't get the type of care we don't want. And I'm a big subscriber of the belief that this is an area that we need to pay a lot more attention to. When I talk to the people that I have the privilege of working with, often they're talking about, the idea that they're afraid that someone may keep them on life support when there's no hope of recovery, and that they won't have comfort in the last days of their lives, and tell us constantly stories of other loved ones who went through pain and agony, and they want to make sure that that's not what their future looks like there, and that they have control over what they want regarding end-of-life, life-sustaining treatment there. And yes, having dealt with all of that, we all wish to leave a legacy to our loved ones in terms of making our wishes known, and whatever we have when we're gone, that is passed on to our loved ones in the most efficient way, the most cost-effective way, and done in a way that is supportive of our loved ones and doesn't necessarily result in, if someone is not capable of handling a lump sum because of age or financial maturity, that it's given to them in the right way. And whatever that probate stuff is, that if that makes sense to avoid it there. And having that documented, obviously, in the proper documents, whether that be a will or a trust. Now, just quickly, I mentioned probate. Probate is part of our court system, and it's the legal procedures and vehicle that is used when we can't take care of ourselves and we have assets. And so there's 2 times that we can go through probate: while alive and after death. While we're alive, that's often referred to a conservatorship or a guardianship, and I'll talk more about that in a few minutes. And at death, a death probate. But there are ways that we can avoid the use of the court if that becomes important to you. And as we go on, we'll talk about that. So, one of the things that I often see people will say to me is, Terry, I understand there's tools and what have you, but we don't need that because we have developed a system ourselves within our family. And first of all, we have all of our assets, if I'm married, held jointly, or if I'm not married, with my, an adult child or another loved one, a sibling or someone there. Now, does that work? Well, it depends on what you're trying to do. With a spouse or a partner, it allows either of you to access the assets and to be able to either of you to deal with some types of assets independently of the other, but other types it requires both of you. So for example, if there's 2 of you on the deed of a house, in order to do anything, whether it's sell it or remortgage or what have you, it would require both of you to do it together. But on the other hand, if there's 2 of you on a checking account, so my wife's name is Maria, if it says Terry and Maria Bertram on the checking account, either one of us can write a check for whatever is in that account there. And we're not limited to half of it. We're not requiring the other spouse to sign off in order to write a check, obviously, there. So it works from that standpoint. But now what if we're both incapacitated? It doesn't work anymore because no one's got the authority on there. And like I said, there are some types of assets, stocks, bonds, real estate, that if there's more than one name on it, it requires all the parties on there to be able to act together. I had a situation once where a single woman put her son on her real estate with the idea that upon her death, it would go to him automatically. But then she ran into a situation where she needed long-term care, and she would have been able to qualify for Medicaid assistance, but her son was on the property. And so in attempting to assist her in being qualified for Medicaid, we wanted to take the son off and just put it in her name, because with Medicaid, you're allowed to have a home, but it's got to be in your name. If someone else's name is on there, in that case, it's considered a divestment, and that's a bad thing, as it could, you could be disqualified as a result of this. The son was in marital problems at the time and unable to and unwilling to remove his name from the property. As a result of that, mom was not able to qualify for Medicaid assistance as soon as she would have been able to otherwise, and had to go through a period of divestment because the Medicaid folks viewed that she had given this asset to her son when she shouldn't have, to become qualified for Medicaid. So it can be a problem that way. And whenever you put anyone else on, you have to realize you're taking on their issues. So if there is a divorce, if they have creditor problems, if there's a bad kid, I mean, in terms of whether they're a spendthrift, they don't know how to hold on to money, or, you know, they have bankruptcy issues or their own creditor issues, or, you know, the other thing is sometimes, like, I was one of 7 children, as I said, and before, you know, I knew one time I was looking at my mom's stuff and she had put my name on one of her accounts. And I go, Mom, why'd you do that? She says, well, I know you're a lawyer. You understand this stuff and that you could help out if it's needed. And I had to say to her, you know, that's not a good thing to do. You need to take my name off from that. And instead we can use powers of attorneys or a trust or what have you. And I'll talk about that later, because with me on there, if something happens to me, I don't have to, if something happens to her and I now have this account in my name only, I don't have to share it with my other brothers. Now, my mom would have wanted me to, morally and ethically, I would have had, you know, her wishes there, but legally, I would have no obligation to do that. So that's not a good thing. And then further, you put someone else's name on it, they would be subject to your capital gains and possibly gift taxes. You can give someone $15,000 a year, gift tax free. If it's above that, it's subject to gift taxes. And you can also have capital gains tax. So what do I mean by that? Let's say, in my mom's instance, that she bought her house for $75,000 and it's now worth $125,000. So there's $50,000 of gain that has occurred during the years there. If she puts my name on that house, I get it at her basis, meaning $75,000, and I would have to pay capital gains on her $50,000 of gain. Whereas if I receive it upon her death, I get what's called a step up in basis, which means I get it for the $125,000 and there is no capital gains tax that needs to be paid. So I often tell people it's better to inherit assets than to have your name put on assets during your loved one's life, because you are taking on any of these tax obligations that you would otherwise are wiped out at death there. And then finally, the long-term care planning. I mentioned it about the mom and the son, but in addition to that, You know, there are other instances where people will put other people on different assets, and that can sabotage their ability to otherwise qualify for long-term care. And so it's really important that you be careful. And one of the basic rules that I go by in anyone doing planning is to say the only person, if you're going to have someone else on a joint account that you should have, is a spouse or a partner. And other than that, do not have your children or siblings or anyone else on your accounts as a co-owner, because that can create problems, whether it's tax, their creditor problems, or liabilities in the future there. But then you say, okay, if I'm not supposed to have someone on the account, how do I make sure that they can deal with things? Well, so you don't have anyone on the account and you don't have any tools in place. And now all of a sudden you're incapacitated. What happens then? Well, that's where oftentimes we have to go to the probate court for either a guardianship or a conservatorship. A guardianship is that proceeding if someone needs to make decisions on your behalf regarding where you're going to live, what type of medical treatment you're going to get, and things of that sort. It's called of the person. You know, how do we help this person as they navigate through life and they're unable to make decisions for themselves? A conservatorship, on the other hand, is where we're handling a person's resources, their assets, their financial matters, and that. Now, some people need one or the other. Oftentimes, someone has to have both if they don't have the tools in place ahead of time. And I must say that these type of proceedings are hard on everyone. They're hard on our loved one who is becoming or is incapacitated, and the family members in deciding the best way and who's best to become a guardian or conservator. And it's not because the judges there recognize that they are performing an action that the only other place that occurs is in our criminal courts, where we're taking away the civil rights of someone and giving it to somebody else. So even though it may be the most loving family, the court can't not do its job on making sure that this is the right thing to do and getting clear and convincing objective evidence that indeed this person is A, unable to manage their affairs, and B, with the appointment of a guardianship or conservatorship, they would be able to be properly managed for their benefit. As a result, it's a proceeding that's expensive, it's time consuming, often humiliating for the loved one who needs assistance. And, you know, it is a procedure that is not one of these, once it's done, it's done. Because the court has granted control to a guardian or conservatorship, they now want to monitor, as we would hope they would, how well it's working. And so the guardian and the conservator must present reporting to the court. If it's a conservatorship, accounting as to monies going in, monies going out. If it's a guardianship, where the person is living, what kind of health issues are they dealing with, how has the guardian met them, and are they meeting with them on a regular basis, and is the placement appropriate there? So the court is going to be engaged in as long as that guardianship or conservatorship is needed there. And it's something that most of us would want to be able to avoid if we could. And one of the ways that we can go about avoiding that in terms of that toolkit that we need is having comprehensive property power of attorney. Another way that you will hear about this. It's called a financial power of attorney or a durable financial power of attorney. These are all powers of attorney is a legal document where you're appointing someone to be able to make financial decisions for you if you can't make them for yourself. The question that you have to ask if you have a power of attorney is, when does it come into effect? Is it effective now, or does it only become effective upon my disability? And how is that defined? Is it my physician, or does it require a second opinion? How does it work? You ought to know that and make sure you have it set up the way you want. You can have it where it is only effective upon some occurrence, or you can have it having immediate effect. And most of the families that I work with, frankly, they would want it to have immediate effect, where even without giving up control, they could give it to someone and they could use it on their behalf there. Secondly, is it comprehensive? When I first started practicing law, my powers of attorneys were 2 pages long. And they were 2 pages long because is all that I had to do is say, I hereby appoint my spouse, Maria, as my power of attorney, and she can do anything I can do. In 2012, the legislature saw that as being what I refer to as a blank check. And while in some instances they were used as we wanted to, it was also used at times, frankly, for elder abuse and, theft, even amongst family members, because it didn't define what the powers were that someone had. And so therefore, the legislature said, if you're going to allow someone to do something, you got to state what it is they can do. And so as a result of that, we, what was a 2-page document, and it's now in our practice become approximately a 26-page document. We enumerate the different scenarios that might point to do some long-term care planning. It may be that they need to create a type of trust that allows us to sequester some of our money, reposition it, if you will, so that we could qualify for long-term care assistance with either the VA or for Medicaid sooner rather than later there. And maybe we want to be able to make sure that we can continue to address any gifting that you have already done to be able to assist a family member. And so we want to make sure that there is a financial power in place, that it's not too old. As I said, the legislature passed a law in 2012. It was actually October 1 of 2012. You have one that was done before that. The legislature didn't say that that one was obsolete. But through practice, we have seen in the real world, the financial institutions and even the government agencies are rather leery and don't always accept those that were done prior to that. And so we strongly suggest that if your power of attorney was done prior to October 2012, that you consider getting it updated. There's an additional provision that was put into the powers of attorneys were to indemnify the financial institutions for accepting it, where it's to give them an incentive to accept it, in as much as the person you appoint as a power of attorney has to sign something on that power of attorney agreeing they're going to act in your best interest. They're not going to commingle your money, and they will provide accountings for it. And, basically, thou shalt not steal there. And that's important for the financial institutions to know that whoever is acting on that power of attorney knows the rules of the road, if you will. So a very critical tool to help you when you can't help yourself, or to have a helper if you're still competent, but you need someone to do some things. As I was talking about my mother, where at first she thought the best way of dealing was putting me on accounts, and no, rather instead I had, she knew where to go to get it somehow, to get a comprehensive power of attorney. But where I had her power of attorney, and while she was not mobile, she had her wits about her, so she wasn't willing to give up control, but she wanted me to do some of her financial stuff for her. So it was like, Terry, I need you to go to the bank. I need you to move this money to over here, and giving me the authority to do things in her best interest without her giving up control. And through the proper financial power of attorney, you can do that. The other thing that we need, the second tool, if you will, is to have a healthcare power of attorney. And now these come in different names, and it's basically we're talking about appointing someone to make healthcare decisions for us if we can't make them ourselves, as well as indicating what we would want or not want regarding end-of-life, life-sustaining treatment there. So other names you'll hear is healthcare proxy, a patient advocate form, an advance directive. Those all are talking about a legal document where you're appointing someone to make decisions for you. And in Michigan, we call that a patient advocate. And also within that document, indicating what's important to you. Not just, in the days of our life as to what do I want in terms of treatment or comfort care, I'm in the declining process there, but also what are my values? Is my main goal to live as long as possible no matter what, or is the focus on the quality of life and being comfortable and the type of care that goes with? Do I want hospice care when the treatment would just prolong a rough death, if you will, versus the inevitable? And as I understand, the statistics haven't changed much. From what I hear, 100% of us are going to die. And I think it's important for all of us to say and leave instructions on what's important to us and how we hope that to look when we're in that situation there. And so this is a tool that's absolutely critical that we have to be able to do that. And then a companion document for both of these is, whether it's for the financial power of attorney, the healthcare power, or whether we have a trust or anything else, is to have a HIPAA authorization. HIPAA is the federal healthcare privacy law that says our healthcare information is confidential. But there are times that we want our loved ones to be able to talk to our healthcare providers, get healthcare information, perhaps get a note from a physician that says the level of our competency if we have a springing power of attorney, so that can become effective. And to do that, you need a standalone HIPAA authorization indicating to the medical community who has to get your healthcare information when you can't pre-authorize it there, or you can't authorize it at that time because of your own level of competency, whether, I'm being admitted to the hospital and I'm unconscious. I need to make sure that my loved ones can talk to my providers without any problems, or call the nursing station to check up on me and that. So we all need that. So the legal toolkit that we all need are these three documents: the financial power of attorney, the healthcare power of attorney, and the HIPAA authorization. That allows us to have helpers when we go through different stages of our lives there, because when we get involved where we need some type of assistance as we're aging in that, when it can no longer be met on our own without any assistance of friends or loved ones, and we enter this maze, we need to have these tools available for others to help us, because it can quickly, very fast overwhelm us with, a myriad of issues. And it's not just our health and the changes that occur with that, but it intersects with our legal and financial issues there. And oftentimes our loved ones who are there to help us are going to be overwhelmed at all with all of this and wondering what they can do and how do they go about doing that? Now, you know, we have the healthcare system, but right now we have to distinguish between acute care and chronic care there. Chronic care issues raise a lot of important issues. And by chronic care, I mean when we have something that happens to us and it becomes a continuing problem, you know, whether I've had a stroke or I had dementia, Alzheimer's, and different things where I'm declining over time there versus acute care, you know, something, I break a bone, I get it set, it's put in a cast, I'm done with it, you know, where different things occur that way there. And as a result of chronic problems, we want to figure out how do we get the best quality of care no matter where we're living and maintain or improve our quality of life in that situation. And how do we then access the benefits that are available to us? And what am I going to be paying out of pocket? What assets am I going to use? What can I qualify for? And what can I, as a caregiver now, do to help a loved one there? What authority do I have in that scenario? And finally, we all want to do this in an efficient way. If we can protect assets, make sure our loved ones, our spouse and or our beneficiaries after our death, that we're leaving them what we can, but also taking care of ourselves and not having a tug of war between the two as much as possible there. So what we're trying to accomplish is how does a person with a chronic illness find, get, and pay for good long-term care, wherever that is, whether it's in our home, in a supportive living, or in a more involved scenario there. Now, one of the misnomers that people have is that Medicare will pay for whatever I need, and I don't need to think about the money cost there. But Medicare covers acute care needs. It doesn't cover ongoing chronic care needs. If Medicare will take care of you for a short period of time, so if I were to have a stroke and go into the hospital, it will cover that hospitalization so long as I've been in there and admitted and in there for at least 3 midnights. And then I need to go to some rehab and or long-term care assistance for the first 20 days Medicare will pay, and then possibly up to 100 days, but in no cases go beyond 100 days. After that, if I need to continue to get assistance, either my assets and income needs to be used, or if I have a long-term care policy, obviously, but otherwise, the other 2 programs are available is through the Veterans Administration or the Medicaid system there. So whenever we have folks who come to us and are talking about what's all going on, we try to put this together in a picture. And I want to take you through this elder care continuum chart, if you will. So the top line is dealing with what's happening to us or our loved one who has issues at this point in time. Where are they functioning? Do they have, at this point, you know, limited function, more limited function, even more limited? What is going on in their scenario? And not just what's going on with their scenario, where are they living at that point in time? So if I have someone who has more limited function and they're living at home by themselves, that could be a problem. What we don't want to happen is because someone has limited function and they're living at home without any supports, that some crisis occurs and they boomerang from being at home all the way over to a nursing home. Whereas if they have limited function and they get the supports they need, whether it's home health care coming into the home or they need to move to a more supportive environment, I'll make a continuing care community, retirement community, or something else, then we ought to look at that. But obviously, when we are trying to match up someone's function with where they ought to be living, we know all of these things on the third line here, that the cost goes up. And how are we going to pay for it then? And when we look at how we're going to pay for it, we then go to this bottom line. We obviously have our own assets and income, but then there's VA benefits, there's community services, Social Security benefits, families who can help, and then Medicaid and Medicare to a limited extent there. So in this outer law continuum, we're trying to match up with someone's safety and independence resulting in where they live and the dignity of risk. One of the things I always, when I'm working with families, making sure I understand who is interested in getting support. Is it the family who's not living there for their peace of mind? Is it the individual themselves who recognizes they need more help? And what's the balance? Because sometimes I'm representing an elderly person who recognizes that they're taking more risk than maybe their family would like, but there's a dignity of risk too, where sometimes people want to take that risk, and it's our job to advocate for that and look at other ways that they can do that. And maybe, you know, that's where we call maybe Housing Bureau Seniors saying, hey, maybe consider someone moving in with them that they're willing to consider, or other things of that sort. Look at different ways that we can handle that. Because oftentimes when something bad happens, people are confused, and all of a sudden they will have a whole lot of questions. Who's in charge? What's going on? Mom has dementia. We had to move her to a retirement community. What should we do with her condo? How do I know whether mom's insurance is paying everything it should? Since I'm the executor of mom's will, can I write checks and handle her affairs? No, you can't. Will we have to sell everything to pay for the long-term care? How do I resolve quality of care issues? What senior service agencies can help? These are all questions people have, and what we want to try to do is assist them as elder law attorneys, sort of quarterback, but not do the different things there. Make sure that they have the legal tools in place, protect what assets they can, and then figuring out how to pay for long-term care and get the best care for what becomes necessary as we go along in life there. There's an old saying there, and I know none of us have traveled on airplanes recently there, but when we did, you may recall at the beginning, there's the safety presentation. And the flight attendant says, when the oxygen mask comes down, the first thing you're supposed to do is put it on you. And then if you have a child or a loved one who would have problems with it, then put it on them. Because the rule is, you can take care of someone else better if you've first taken care of yourself. And that is the case with this, is if you take care of yourself, you're more likely to have preserved the maximum amount of your estate by being the most efficient here, by planning for the worst and hoping for the best. You've got the tools in place that someone can help you if that becomes necessary. And you're more likely at the end to live your best life and leave your best inheritance to others there. And so, you know, the blessing of this community is we have a lot of resources that can help us to do that. The curse of this community is we have a lot of resources, a lot of people who can help you, but we got to figure out where they're at and what are the right ones for us there. And make sure you have those trusted advisors in your life who are there when you need them. And in terms of when you look at who do I hire or work, you want to make sure they have the technical knowledge, but this is someone that you will need to rely on possibly in the future, a trusted advisor. You want to make sure that you get along with them and they get along with you. You know, when we talk to prospects who meet with us, you know, yes, that they want to make sure, and that's important too, that we've got the technical knowledge of all that, but to also just make sure we click, that we'll work well together there, because that becomes critical as we move ahead there. Because we want to make sure the right tools are in place, but that it's a plan. that the pieces fit together, that the puzzle works now, and that gives you the peace of mind so that if something were to happen in the future, that everything will be smooth. And also, upon your death, that your estate transfers the way you want in the most efficient manner, and in a way that you know, you leave the legacy that's important to you. At this point, I'm finished with my presentation and want to make it available, Courtney, now for any questions and answers that I might be able to provide folks.
All right, so we are going to take some questions. Just go ahead and type in the question and answer box at the bottom of your screen, and we will be able to answer those for you. Just give a minute to people. So we're being asked, will this recording be available? So the recording will be available on the HPS website. I'm not sure, Terry, how you feel if people are asking for you to provide slides. What would your response be to that?
Well, one, I think, you know, you're going to have the recording available to them, and that obviously it has the slides there. That's probably the easiest way of doing that. But if someone contacts us directly and asks for that, because I don't have contact information, I'd be happy to make sure you can get this.
It looks like we have a question from Bill Hoyt. Can you hear from power of attorney, financial and medical?
That's a question. And basically, we do everything we can to avoid doing that. But as a last resort, we do serve as a financial attorney at time and look at other resources to assist people with power of attorney. And that's just because we want to make sure you get the best of every need. You know, medical social workers, there's geriatric care coordinators, there's other folks who are in a better position to give the time and effort and the use of medical things that can better serve as your healthcare advocate. And we can, if necessary, while we serve as financial power of attorney, we want to use other resources too, because you know we're not a bank, we can't invest money with ourselves, and so we use third parties to assist us. But in terms of writing checks, making sure they'll stay on, things like that, in the worst scenario, we can do that.
Awesome answer. Excuse me. Carolyn White has a question. Where do we find the HIPAA compliant general medical release?
So I'm not aware that there's a document that you can find that's generic, so it can go to any health provider that's out there. That's why we produce a draft one for our clients there. There's a lot of HIPAAs out there that are specific to an entity, so if you go to a provider, they will for that, and you're at that time indicating who can access medical information. But frankly, you can go to a lawyer to have the draft one for you that's generic, so that it can be used whoever the medical provider is that you have. It's a good question.
An anonymous question. How can we get these documents if our families staying at home due to COVID?
So the governor in a situation where someone can't come into an office. By the way, and I'm sure other law offices are similar. We've had a lot of technical assistance by the state bar and the local bar to make sure that our resigning program, especially dealing with vulnerable folks here with this pandemic. So we have a plexiglass industry where we have a plexiglass offices. We wear masks, gloves, and different things, and wipe everything out and have hand sanitizer all over the place, what have you, for those who want to come to our building, which is also the latest on a day basis there. But also our governor and our boards has allowed us, it was just said yesterday, now through the October, where in instances where people are unable or unwilling to leave their home, that you can get documents signed, witnessed, and notarized remotely. Her latest executive order extends that through the end of October. So that's available as another tool that we have to assist to get these documents done in the near term.
Okay. So just waiting if anybody else has any other questions.
So two of the major legal insurance programs that we see in this area here. So the answer is yes.
Would you please explain the example you mentioned about the homeowner's name with your children regarding the tax issues?
Yes. So if, in my example, mom owns her house, and as I said, she paid $75,000 for it, and it's now worth $125,000, so increased in value by $50,000. If my name is put on during her life, I assume her basis, and therefore I am responsible for gains tax on the difference that she paid, the $75,000. And if I sell it for $105,000, that $50,000, I must pay capital gains tax on it. Whereas she paid $75,000, and it's in her trust or will that says, Terry, you inherited upon my death. So I don't get it now, my name's not put on it, but at death I receive it, and it's worth $125,000. That's got to step up in basis. So if I were to sell it, I don't have to pay any capital gains tax. Nobody cares what she paid for it because I got it at death versus I was put on asset during life. And that occurs also with stocks and other things that increase in value. So I tell people it's always better to inherit an asset than to be put on it during life, because you assume that person's basis and you've got to pay capital gains tax on it, just like if they were to sell it there. And so it's better to inherit than to receive it during life. And plus all the other myriad of issues that you run into if it's on there during life, and loss of long-term care, assistance, and other things.
My husband has a stock fund. I'm sorry, this is Tammy Mori. My husband has a stock fund. Should I have him take me off the account?
So Tammy, I don't know. I don't know the answer to that because I don't know what kind of planning you have there. So first of all, if there's no plan and you're a spouse, I don't see that as being a problem there. You just want to make sure you have comprehensive powers of attorneys there, and whatever type of plan you have as to what occurs after your death. If you've got a trust, neither of your names should be on it as the owners, but rather your trust ought to be the owner of it. So I've got, again, as I said, my wife's name is Maria. So instead of an account being in either my name or my name with my spouse on it as husband and wife, we're on there. It's Maria and Terry Bertram, trustees of the Maria and Terry Bertram Trust. And we know the trust doesn't get sick and it doesn't die. It says who's in charge when we get sick and who's in charge and who gets it upon our death there. And so titling of assets is a very, very, very important issue, and it can impact sabotage your efforts to get long-term care. It can talk about who gets an asset upon your disability or death and impact the taxes and what have you. So it's a critical issue. And so while it probably, Tammy, is okay in your circumstance, I can't be certain without knowing a lot more about your circumstances on what would be the right way of holding your assets.
Okay, and do you accept U of M's legal plan?
So the U of M legal plan is the MetLife legal plan that someone else asked for. They're one and the same. So the answer is yes.
Thank you.